I never thought a tomato plant would land me in court, but then again, I never thought I would meet someone like Brenda Morrison either. It started on a Tuesday morning in May when I was kneeling in my front yard in Scottsdale, Arizona, tending to the vegetable garden I had spent 3 months carefully planning and planting. The Arizona sun was already hot at 9 in the morning, and I was wearing my oldest jeans and a faded university shirt, my hands deep in the rich soil as I checked on my tomato plants. I had just moved into the Sunset Ridge community 6 months earlier, a neat collection of Mediterranean-style homes with terracotta roofs and stucco walls. The neighborhood was beautiful, quiet, and exactly what I needed after my divorce. My name is Lucas Patterson, and at 38 years old, I was finally starting to feel like I was building something of my own again. The garden was my pride and joy. I had always wanted to grow my own vegetables, and the previous owner of my house had left the front yard relatively bare, except for some basic desert landscaping. I spent weeks researching what would grow well in Arizona's climate, consulted with experts at the local nursery, and even hired a landscape designer to help me create a plan that would be both beautiful and functional. The result was a stunning mix of raised beds filled with tomatoes, peppers, squash, and herbs, interspersed with native desert plants and flowering bushes. It looked like something out of a gardening magazine, and my neighbors had been stopping by regularly to compliment me on it. That is, until Brenda Morrison arrived at my front gate that Tuesday morning. I heard the click of her heels on the sidewalk before I saw her. When I looked up, shielding my eyes from the sun, I saw a woman in her mid-50s marching toward me with a clipboard clutched to her chest like a shield. She was wearing a cream-colored pantsuit despite the heat, and her blonde hair was styled in that particular way that screamed suburban authority. Her lips were pressed into a thin line, and her eyes were hidden behind oversized sunglasses. "Excuse me," she said, her voice sharp and nasal. "Are you Lucas Patterson?" I stood up, brushing dirt off my knees. "That's me. Can I help you?" She did not smile. "I'm Brenda Morrison, president of the Sunset Ridge Homeowners Association. We need to discuss your front yard immediately." I glanced back at my garden, confused. "Okay. What about it?" She pulled her sunglasses down just enough to peer at me over the rims. "What about it? Mr. Patterson, you have violated at least 7 different sections of our community covenants, conditions, and restrictions. This vegetable garden is completely unacceptable." I felt my stomach drop. When I bought the house, I had read through the HOA documents carefully. They were extensive, over 100 pages of rules and regulations, but I had not seen anything that prohibited vegetable gardens. In fact, Arizona state law protected homeowners' rights to grow food in their yards. "I'm sorry, but I don't think that's correct," I said, keeping my voice calm. "I reviewed the HOA rules before I planted anything. There's nothing in there about vegetable gardens." Brenda's nostrils flared. Section 12. Paragraph 4 clearly states that all front yard landscaping must maintain a cohesive aesthetic consistent with the desert Mediterranean theme of the community. Your vegetables are an eyesore and are bringing down property values. An eyesore. I looked at my garden again. The raised beds were made from beautiful cedar wood that I had stained a rich brown. The plants were healthy and vibrant, with glossy green leaves and bright flowers. The whole area was meticulously maintained, with fresh mulch and not a weed in sight. I've had at least a dozen neighbors tell me how much they love it. "Those neighbors are not on the HOA board," Brenda snapped. "I'm giving you 14 days to remove all vegetable plants and replace them with appropriate landscaping. Failure to comply will result in daily fines of $100. my hands clenched into fists at my sides. $100 per day was absurd. You can't do that. Arizona Revised Statute 33-18-18 specifically protects homeowners' rights to grow food plants in their yards. Brenda's smile was cold. That statute has exceptions for HOA communities with existing restrictions. I suggest you read your documents more carefully, Mr. Patterson. 14 days. Have a nice day. She turned on her heel and walked back down the sidewalk, leaving me standing there in shock. I immediately went inside, pulled out my copy of the HOA documents, and started reading. I spent the next 3 hours going through every single page, and nowhere could I find any clear prohibition against vegetable gardens. Section 12. Paragraph 4 did mention maintaining aesthetic standards, but it was vague enough that my well-designed garden should have been completely acceptable. Over the next few days, I did my research. I called the Arizona Department of Real Estate, spoke with a lawyer friend, and even reached out to a local advocacy group that dealt with HOA disputes. Everyone told me the same thing. The state law protecting food gardens was relatively new, passed in 2019, and it did supersede most HOA restrictions. The only exception was if the HOA could prove that the garden created a genuine health or safety hazard, which mine clearly did not. Armed with this information, I drafted a polite but firm letter to Brenda Morrison and the HOA board. I cited the relevant statute, included photos of my garden showing how well maintained it was, and even attached letters from 3 neighbors expressing their support. I sent it via certified mail and waited. The response came 6 days later. It was not what I hoped for. The letter, signed by Brenda Morrison on behalf of the HOA board, stated that they had reviewed my concerns and found them without merit. They claimed that my interpretation of the state statute was incorrect and that their aesthetic standards took precedence. Furthermore, because I had not yet begun removing the garden, they were now assessing fines starting from the original deadline. I owed $1,400, with an additional $100 being added each day. I could not believe it. I immediately called the phone number listed for the HOA management company, but I was told that all disputes had to be handled in writing through Brenda Morrison directly. When I tried to reach Brenda, her phone went straight to voicemail every time. I left 3 messages over 2 days. None were returned. The next Tuesday, exactly 3 weeks after my first encounter with Brenda, I found a notice taped to my front door. It was another letter from the HOA, this one informing me that I now owed $2,800 in fines. If I did not pay within 10 days, they would place a lien on my property. A lien over a vegetable garden. I was furious. I spent that evening researching lawyers who specialized in HOA disputes. I found one named Richard Chen who had an office in Phoenix, about a 20-minute drive from my house. I called first thing the next morning and explained my situation. He agreed to meet with me that afternoon. Richard's office was in a modern building with glass walls and sleek furniture. He was younger than I expected, maybe in his early 40s, with sharp eyes and a confident handshake. I showed him all my documentation, the HOA rules, the letters from Brenda, photos of my garden, and the state statute I was relying on. He reviewed everything carefully, occasionally making notes on a legal pad. Finally, he looked up at me and said, "Mr. Patterson, you have an excellent case. The state law is very clear, and your garden is exactly the type of food cultivation it was designed to protect. The HOA is completely overstepping their authority." Relief washed over me. So what do I do? First, I'm going to send them a letter on your behalf explaining why their actions are illegal and demanding that they rescind all fines. If they don't respond appropriately within a reasonable time frame, we'll file a lawsuit. Based on what you've shown me, I believe we can not only get the fines dismissed, but also potentially recover damages for harassment and emotional distress. How much will this cost me? I asked, worried about legal fees on top of everything else. My retainer is $3,000, but in cases like this where the HOA is clearly acting in bad faith, we often recover attorney fees as part of the judgment. I'm confident we can get your money back. I thought about it for a moment. $3,000 was a lot, but the HOA was already trying to charge me more than that in bogus fines. And more importantly, this was about principle. I had worked hard on that garden. It was beautiful, legal, and meant something to me. I was not going to let some petty tyrant bully me into destroying it. Let's do it, I said. Richard drafted a letter that same day. It was 3 pages of precise legal language that essentially told the HOA they were violating state law and needed to back off immediately. He sent it via certified mail and email to both Brenda Morrison and the HOA's management company. We waited. For 5 days, there was no response. Then, on a Monday morning, I received yet another letter from the HOA. This one informed me that due to my continued non-compliance and hostile attitude toward the board, they were increasing the daily fine to $250. I now allegedly owed over $6,000. When I called Richard to tell him, I could hear the anger in his usually calm voice. They're either completely ignorant of the law or they're banking on you backing down because you can't afford to fight them. Either way, this is going to look very bad for them in court. I'm filing the lawsuit today. True to his word, Richard filed a complaint in Maricopa County Superior Court that afternoon. The lawsuit named the Sunset Ridge Homeowners Association and Brenda Morrison personally as defendants. We were seeking a declaratory judgment that my garden was legal, an injunction preventing the HOA from interfering with it, dismissal of all fines and damages for harassment and emotional distress. The next few weeks were stressful. Every morning I would go out to tend my garden, expecting to find some new notice or threat from the HOA. My tomatoes were starting to produce fruit, beautiful red globes that should have brought me joy, but instead I felt anxious every time I looked at them. I had trouble sleeping. I found myself constantly checking my mailbox and email for updates. The HOA was served with our lawsuit in early June. They had 30 days to respond. During that time, something strange started happening. Brenda Morrison began showing up at my house at odd hours. She would stand at the edge of my property line, always holding that damn clipboard, and just stare at my garden. She never said anything, just stood there for 10 or 15 minutes before walking away. It was deeply unsettling. Then the letters started coming to my neighbors. I found out about it when my next-door neighbor, a retired teacher named Margaret, knocked on my door one evening. She was holding a printed flyer. "Lucas, I need to show you something," she said, her face troubled. "Brenda Morrison has been distributing these around the neighborhood." I took the flyer and felt my blood pressure spike. It was a full-page document with the heading "Protecting Our Property Values" in bold letters. Below that was a photo of my garden, taken from an unflattering angle that made the raised beds look messy and unkempt. The text claimed that my illegal farming operation was attracting pests, lowering home values, and violating community standards. It encouraged neighbors to contact the HOA board if they had concerns and included Brenda's personal email address. "This is insane," I said, staring at the flyer in disbelief. "None of this is true. My garden doesn't attract pests and it's not illegal." Margaret nodded sympathetically. I know that, and most of the neighbors know that too. I just thought you should be aware of what she's doing. For what it's worth, I think your garden is lovely, and I told Brenda exactly that when she tried to give me this flyer. I thanked Margaret and immediately called Richard. He told me to save the flyer and document everything. This is actually helpful for our case, he said. It shows a pattern of harassment that goes beyond simple HOA enforcement. She's actively trying to damage your reputation in the community. The HOA's response to our lawsuit arrived in mid-July. Their lawyer, a man named David Frost from a firm that specialized in representing homeowner associations, filed an answer that denied all our claims. They argued that their aesthetic standards were legitimate, that my garden violated those standards, and that the state statute did not apply because their restrictions predated the law. It was all nonsense, but it meant we were going to trial. The discovery phase began. Both sides exchanged documents and submitted written questions that had to be answered under oath. Richard requested copies of all HOA board meeting minutes for the past 2 years, all communications related to my property, and any other instances where the HOA had enforced landscaping rules. What we found was illuminating. The meeting minutes revealed that Brenda Morrison had brought up my garden at 4 separate board meetings, starting just 2 weeks after I finished planting it. In each case, she pushed for aggressive enforcement action. However, the minutes also showed that 2 other board members had expressed concerns about whether the HOA had the legal authority to force me to remove the garden. Brenda had overridden those concerns, insisting that they needed to send a strong message about community standards. Even more interesting was what we found about other properties. In the past 18 months, the HOA had sent violation notices to 11 different homeowners for various landscaping issues. Of those 11, only 2 had resulted in fines, and both fines were quickly rescinded when the homeowners made minor modifications. My case was the only one where the HOA had insisted on complete removal of the landscaping and had assessed such massive fines. It was clear that I was being treated differently. Richard also deposed Brenda Morrison. I was not present for the deposition, but Richard told me afterward that it had been quite revealing. When asked why my garden specifically violated HOA rules, Brenda gave vague answers about aesthetics and property values, but could not point to any specific provision in the HOA documents that prohibited vegetable gardens. When asked about the state law protecting food gardens, she claimed she had consulted with the HOA's attorney and been told it did not apply, but she could not provide any written documentation of that advice. Most damningly, when asked if she had any personal animosity toward me, she had responded, "I just think people who flaunt the rules need to be taught a lesson." That phrase, "taught a lesson," became central to our case. It showed that Brenda's actions were not about legitimate HOA enforcement, but about punishing me for challenging her authority. Summer turned to fall, and my garden continued to thrive. The tomatoes were abundant, and I started growing squash and peppers as well. I made a point of sharing my produce with neighbors, and many of them expressed support for my case. A few even offered to testify on my behalf if needed. The trial was scheduled for late October in a Maricopa County courtroom. As the date approached, I felt increasingly nervous. I had never been involved in a lawsuit before, and the idea of going before a judge was intimidating. Richard tried to reassure me, explaining that we had a strong case and that the law was clearly on our side, but I still spent sleepless nights worrying about what would happen if we lost. The night before the trial, I stood in my front yard as the sun set, looking at the garden I had worked so hard to create. The raised beds were full of healthy plants, their leaves rustling gently in the evening breeze. The garden had become more than just a place to grow vegetables. It represented my fresh start, my independence, my right to make my own choices about my own property. I was not going to let Brenda Morrison take that away from me. The courthouse in downtown Phoenix was an imposing building with stone columns and high ceilings. I arrived early with Richard, both of us dressed in suits, carrying boxes of documents and evidence. The courtroom was smaller than I expected, with wooden benches and a raised platform for the judge's bench. Brenda Morrison was already there with David Frost, her attorney. She was wearing a navy blue dress and had her hair pulled back severely. When she saw me, her expression was one of cold satisfaction, as if she was certain she had already won. The Honorable Judge Patricia Morneau entered the courtroom at exactly 9 o'clock. She was a woman in her early 60s with gray hair and an air of no-nonsense competence. After we all stood and sat back down, she reviewed the case file briefly and then looked up at both legal teams. "All right, gentlemen, Miss Morrison," she said. "I've reviewed the pleadings in this case, and I have to say, this seems relatively straightforward. Mr. Chen, why don't you start by explaining your client's position?" Richard stood and gave a concise summary of the case. He explained that I had created a beautiful, well-maintained vegetable garden in my front yard, that it complied with all applicable laws including Arizona's statute protecting food gardens, and that the HOA had responded with excessive fines and harassment. He emphasized that the HOA's actions appeared to be motivated by personal animosity, rather than legitimate enforcement of community standards. David Frost then presented the HOA's position. He argued that the community had aesthetic standards that all residents agreed to when they purchased their homes, that my garden violated those standards, and that the HOA had a duty to enforce the rules equally for all residents. He claimed that the state statute had an exception for established HOA rules and that our interpretation was incorrect. Judge Morneau listened carefully to both sides, occasionally making notes. Then she said, "I'd like to see photographs of this garden that's causing all the trouble." Richard pulled out a folder containing dozens of high-quality photos I had taken of my garden from various angles and at different times. He also had the unflattering photo from Brenda's flyer for comparison. He handed them to the bailiff, who passed them to the judge. Judge Morneau spent several minutes looking through the photos, her expression growing increasingly puzzled. Finally, she looked up at Brenda Morrison and said, "Miss Morrison, can you explain to me exactly what about this garden violates your HOA's aesthetic standards?" Brenda stood up, even though she did not have to. "Your Honor, the Sunset Ridge community is supposed to have a cohesive Mediterranean desert theme. Vegetable gardens are agricultural, not decorative. They don't fit the character of our neighborhood." "But these photos show a very attractive garden," Judge Morneau said, holding up one of the pictures. "The beds are well constructed, the plants appear healthy and well maintained, and there are decorative elements incorporated throughout. This doesn't look agricultural to me. It looks like ornamental landscaping that happens to produce food." "It's still vegetables, Your Honor," Brenda insisted, her voice rising slightly. "It sets a bad precedent. If we allow one person to do this, everyone will want to do it, and before you know it, the whole neighborhood will look like a farm." Judge Morneau raised an eyebrow. "And if everyone in the neighborhood had gardens this attractive, would that actually be a problem?" Brenda opened her mouth, closed it, and then said, "It's about the rules, Your Honor. We have rules for a reason." "Let's talk about these rules," Judge Morneau said. She picked up a copy of the HOA's CC and Articus and flipped through them. I've read through your covenants, conditions, and restrictions twice now, and I cannot find a specific prohibition against vegetable gardens. Can you point me to the exact language you're relying on?" David Frost stood up. "Your Honor, it's Section 12, Paragraph 4, regarding aesthetic standards. The language requires that all landscaping maintain consistency with the community's theme." "Yes, I read that section," Judge Morneau said, "but it's quite vague. How is a homeowner supposed to know whether their landscaping maintains consistency? And more importantly, how does this specific garden violate that standard when it's clearly been designed with aesthetics in mind?" Frost looked uncomfortable. "Your Honor, the HOA board has discretion to interpret and enforce the standards as they see fit." "Unlimited discretion?" Judge Morneau asked sharply. "So the board can essentially decide that any landscaping they personally don't like is a violation, even if there's no specific rule against it?" "Within reason, yes, Your Honor. That's how HOAs function." Judge Morneau did not look convinced. "Let's move on to the state statute. Mr. Chen, please explain your position on Arizona Revised Statute 33-18-18. Richard stood again and launched into a detailed explanation of the law. He explained that the statute was passed in 2019 specifically to protect homeowners' rights to grow food plants. It explicitly stated that HOA restrictions could not prohibit food gardens unless there was a legitimate health or safety concern. He argued that the HOA had not demonstrated any such concern, and therefore had no legal basis for their enforcement action. Frost countered by arguing that the statute had an exception for HOAs with pre-existing restrictions, which Sunset Ridge had. But Richard was ready for that. He pointed out that the exception only applied if the restrictions were specific and clear, which the HOA's aesthetic standard clause was not. Furthermore, even if the exception applied, the statute required HOAs to act reasonably, and imposing massive fines and threatening a property lien over a well-maintained garden was not reasonable by any definition. Judge Morneau asked several pointed questions of both attorneys, clearly trying to understand the nuances of the law. Then she asked to hear from me directly. I stood up, feeling nervous but also determined. Richard had prepared me for this moment. Judge Morneau asked me to describe how I had planned and created the garden, why it was important to me, and how the HOA's actions had affected me. I told her about spending weeks researching plants that would grow well in Arizona's climate, about consulting with professionals to design a garden that would be both beautiful and functional, about the care I put into maintaining it every day. I explained that gardening had become a form of therapy for me after my divorce, that it gave me a sense of purpose and accomplishment. I also described the stress and anxiety I had experienced over the past months, the sleepless nights worrying about losing my home over fines I believed were completely unjust, the embarrassment of having my neighbor receive flyers that falsely portrayed me as some kind of problem resident. When I finished, Judge Morneau nodded thoughtfully. "Thank you, Mr. Patterson. Miss Morrison, I'd like to hear from you as well. Can you explain why the HOA has taken such an aggressive stance on this issue?" Brenda stood up again. Her face was flushed, and I could see her hands were shaking slightly. "Your Honor, I've been president of this HOA for 6 years. In that time, I've worked hard to maintain our property values and our community standards." Mr. Patterson moved in and immediately started flouting the rules. He didn't ask permission, he didn't consult with the board, he just did whatever he wanted. That kind of attitude is destructive to a community. If I had let it slide, it would have sent a message that our rules don't matter. "But what rule did he actually break?" Judge Morneau asked. You still haven't identified a specific provision that prohibits what he did. The aesthetic standard, Brenda said stubbornly. His garden doesn't fit our community's aesthetic. According to whom? Judge Morneau pressed. Mr. Patterson has submitted letters from several neighbors saying they think the garden is beautiful. Your own deposition testimony indicates that only you and one other board member wanted to pursue this enforcement action. It seems like this is more about your personal opinion than any objective community standard. Brenda's face grew even redder. With all due respect, Your Honor, I don't think you understand how difficult it is to maintain standards in an HOA. People are always trying to do things that bring down property values. You have to be firm, or everything falls apart. Judge Morneau's expression hardened. Miss Morrison, I think I understand perfectly well. What I'm seeing here is an HOA president who has decided to wage a personal campaign against a homeowner over a garden that, by all objective measures, is attractive and well-maintained. The fines you've imposed are excessive to the point of being punitive. The threatening letters, the flyers distributed to neighbors, the constant monitoring of Mr. Patterson's property, all of this goes well beyond reasonable HOA enforcement. It looks like harassment, plain and simple. The courtroom was silent. I could see Brenda's lawyer lean over and whisper something to her, but she shook her head firmly. Judge Morneau continued, "Let me be very clear about something. HOAs serve an important function in maintaining communities, but they are not above the law. Arizona Revised Statute 33-18-18 was passed by our state legislature for a specific reason: to protect homeowners' rights to grow food. The legislature recognized that, in a state with abundant sunshine and a growing interest in local food production, homeowners should be able to use their property to cultivate edible plants. The statute explicitly limits HOA authority in this area, and that limitation is not optional." She picked up the statute and read directly from it. It says, and I quote, "A planned community shall not prohibit the cultivation of food plants in gardens or other suitable space, either in front or backyards, as long as the plants are not maintained in a manner that is substantially detrimental to the health, safety, or welfare of the community, or is a significant nuisance to other residents." Mr. Patterson's garden clearly meets this standard. It's well maintained, poses no health or safety risk, and multiple neighbors have testified that they find it attractive rather than a nuisance. She set the statute down and looked directly at Brenda. "Miss Morrison, your HOA's actions in this case have been unreasonable, excessive, and appear to be motivated by personal animus rather than legitimate enforcement of community standards. The fines you've imposed are not only unwarranted, but also appear designed to financially pressure Mr. Patterson into compliance with demands that have no legal basis. This is exactly the kind of HOA overreach that gives homeowner associations a bad reputation." I felt a surge of vindication. Judge Morneau got it. She understood exactly what had been happening. The judge continued, "Furthermore, the evidence shows a pattern of harassment that goes beyond simple fine assessment. The repeated appearances at Mr. Patterson's property, the distribution of misleading flyers to neighbors, the refusal to engage in good faith communication, all of this demonstrates bad faith on the part of the HOA and specifically on your part, Miss Morrison." Brenda tried to interrupt. "Your Honor, I was just trying to do my job. Your job is to enforce reasonable rules in a fair and consistent manner." Judge Morneau cut her off. "That is not what happened here. Instead, you targeted a single homeowner with aggressive enforcement action that you did not apply to other residents, and you did so despite having no clear legal authority. Judge Morneau turned her attention to the legal arguments. She spent several minutes explaining her analysis of the state statute and why she found the HOA's interpretation incorrect. She noted that even if there was some ambiguity in the law, the HOA had a duty to act reasonably, and their actions in this case were anything but reasonable. She pointed out that they could have attempted mediation or other dispute resolution methods before imposing thousands of dollars in fines and threatening a property lien. Then came the ruling. I find in favor of the plaintiff, Mr. Lucas Patterson, on all counts. The Sunset Ridge Homeowners Association's attempt to force removal of Mr. Patterson's vegetable garden is a violation of Arizona Revised Statute 33-18-18 and therefore void and unenforceable. All fines assessed against Mr. Patterson are hereby rescinded, and the HOA is permanently enjoined from interfering with his garden or assessing any future fines related to it. Relief washed over me like a wave. I had won. The garden was safe, but Judge Morneau was not finished. Now, as to the issue of damages, Mr. Patterson has requested compensation for harassment and emotional distress. Normally, I'm somewhat skeptical of emotional distress claims, as they can be difficult to quantify and are sometimes exaggerated. However, in this case, the evidence clearly supports a finding that Miss Morrison and the HOA board acted in bad faith and caused genuine distress to Mr. Patterson. She looked at me. Mr. Patterson, you testified that you experienced sleepless nights, anxiety, and stress as a direct result of the HOA's actions. You've submitted documentation from your doctor confirming that you sought treatment for stress-related symptoms during this dispute. You've also shown that the false information distributed about you in the neighborhood damaged your reputation and caused embarrassment. These are real harms that deserve compensation. Then she turned to Brenda. Miss Morrison, your actions in this case were not just wrong, they were malicious. You used your position of authority within the HOA to wage a personal vendetta against a resident who had done nothing more than exercise his legal right to grow food on his own property. The aggressive fines, the constant monitoring, the distribution of misleading information, all of this was designed to intimidate and pressure Mr. Patterson into submission. That is textbook harassment. Judge Morneau paused, looking down at her notes. The courtroom was absolutely silent. I could hear my own heartbeat. Therefore, she continued, I am awarding Mr. Patterson damages in the amount of $15,000 for harassment and emotional distress. This amount reflects both the actual harm suffered and serves as a punitive measure to discourage similar conduct in the future. I nearly gasped. $15,000. That was more than Richard had suggested we might recover. Additionally, Judge Morneau said, I am awarding Mr. Patterson full recovery of his attorney fees and costs associated with this litigation. HOAs need to understand that when they lose cases like this, particularly when they've acted in bad faith, they will be held financially responsible. These fees are to be calculated and submitted to the court within 30 days. She looked at David Frost. Mr. Frost, I want to be clear that I'm not criticizing you personally. You represented your client as you were ethically obligated to do. However, I hope you will advise the Sunset Ridge HOA board that they need to take a hard look at their governance practices and consider whether Miss Morrison's continued leadership is in the best interest of the community. Then Judge Morneau did something I did not expect. She looked directly at Brenda Morrison and said, Miss Morrison, I want you to understand something. You are extremely fortunate that Mr. Patterson chose to pursue this matter through civil litigation, rather than filing a complaint with the Arizona Department of Real Estate. which oversees HOA conduct. Based on what I've seen in this case, you could potentially face professional sanctions for your actions. I strongly suggest you take this as a learning experience about the appropriate boundaries of HOA authority. Brenda's face had gone from red to pale. She looked like she might be sick. Judge Morneau wrapped up. The court's written order will be filed within 5 business days. Mr. Patterson, you're free to continue maintaining your garden exactly as you see fit. The HOA may not interfere with it in any way. This court is adjourned. The gavel came down with a sharp crack that seemed to echo in the small courtroom. I stood there for a moment, trying to process what had just happened. I had not only won but won decisively. The judge had not just ruled in my favor. She had thoroughly criticized the HOA's actions and awarded me substantial damages. Richard grabbed my hand and shook it vigorously, a huge smile on his face. "That was fantastic," he said. "Judge Morneau absolutely nailed them." I've seen a lot of HOA cases, and I've never seen a judge come down that hard on an association. I turned to look at Brenda Morrison. She was standing at the defense table, her face still pale, her hands gripping the edge of the table. David Frost was speaking quietly to her, but she did not seem to be listening. She looked shell-shocked. As we gathered our materials to leave, Brenda suddenly turned and looked directly at me. For a moment, I thought she might say something, maybe even apologize. Instead, her expression hardened into one of pure hatred. She turned away without a word and walked out of the courtroom, her heels clicking sharply on the floor. "Don't worry about her," Richard said, noticing the exchange. "People like that never admit when they're wrong. The important thing is that you won, and you won big. That $15,000 judgment is going to have to be paid by the HOA, which means it comes out of everyone's HOA dues. The other residents are not going to be happy about that, and I suspect Miss Morrison's days as HOA president are numbered." We left the courthouse and stepped out into the bright Arizona sunshine. It was a beautiful October day, warm but not hot, with a clear blue sky. I took a deep breath, feeling lighter than I had in months. The weight of the lawsuit, the constant stress and anxiety, all of it seemed to lift away. "When can I expect to actually receive the damages?" I asked Richard as we walked to the parking lot. "The HOA has 30 days to pay after the written order is filed. If they don't pay, we can pursue collection actions. Given that this is a formal court judgment, I don't expect them to try to dodge it. They're already in enough trouble." Over the next week, life started to return to normal. I tended my garden without looking over my shoulder, enjoyed the autumn weather, and started sleeping through the night again. The judge's written order was filed 4 days after the hearing, and it was even more thorough than her oral ruling had been. She had included detailed findings of fact and conclusions of law that laid out exactly why the HOA's actions were improper. Then things got interesting in the neighborhood. I learned from Margaret, my neighbor, that an emergency HOA meeting had been called. Apparently, many residents were furious when they learned about the lawsuit and the judgment. The $15,000 in damages, plus the attorney fees which totaled over $12,000, would have to come from the HOA's reserve fund, which meant there would not be enough money for planned community improvements. More importantly, many residents felt that Brenda had overstepped her authority and embarrassed the community. Margaret told me that the meeting was contentious. Several residents stood up and demanded Brenda's resignation. She refused, insisting that she had been trying to protect property values and that the judge's ruling was an overreach of judicial authority. This only made people angrier. Finally, after 2 hours of heated debate, the board took a vote of no confidence. Brenda Morrison was removed as HOA president by a vote of 4-1. She did not take it well. According to Margaret, who heard it from another neighbor who was at the meeting, Brenda had stood up and shouted that everyone was making a huge mistake, that the community would fall apart without her leadership, and that they would all regret turning against her. Then she had stormed out of the meeting. 2 days later, Brenda put her house up for sale. I saw the real estate sign go up from my window. Part of me felt a small twinge of guilt, wondering if I had somehow ruined her life. But then I remembered all the stress she had put me through, the threatening letters, the excessive fines, the campaign to turn my neighbors against me. She had made her own choices, and she had to live with the consequences. The HOA's check for $15,000 arrived 3 weeks after the judgment, exactly as Richard had predicted. The check for attorney fees came a week later. I deposited both checks and then did something that felt deeply satisfying. I hired a professional photographer to take pictures of my garden at sunset, when the light was golden and everything looked perfect. I had the best photo printed and framed, and I hung it in my living room where I could see it every day. I also used some of the damage award to upgrade my garden. I installed a beautiful irrigation system that would make maintenance easier, added some decorative stone pathways between the beds, and planted some additional fruit trees in the backyard. The garden became even more spectacular, but the best part was yet to come. In early November, I received a call from a reporter at the Arizona Republic, the state's largest newspaper. She had heard about my case and wanted to write an article about it. I was hesitant at first, not sure I wanted more attention, but Richard encouraged me to do it. Stories like yours help other homeowners who might be dealing with similar HOA abuse, he said. It's important that people know they have rights. The article ran on a Sunday in mid-November, with the headline "Scottsdale Man Wins Landmark Case Against HOA Over Vegetable Garden." It featured several of the photos of my garden and included quotes from Judge Morneau's ruling. The article explained the state statute protecting food gardens and noted that many homeowners were unaware of their rights. It also mentioned that I had been awarded damages for harassment, which was unusual in HOA cases. The response was overwhelming. I received dozens of emails from people all over Arizona who were dealing with their own HOA disputes. Some were fighting over gardens, others over solar panels or xeriscaping. Many just wanted to thank me for standing up to an overbearing HOA and giving them hope that they could do the same. A few even asked if I could help them with their cases, though I had to explain that I was not a lawyer and could only suggest they contact someone like Richard. The story also caught the attention of state lawmakers. In January, a state representative from Phoenix introduced a bill to strengthen Arizona's food garden protection law. The proposed legislation would make it even clearer that HOAs could not prohibit food gardens and would establish specific penalties for HOAs that violated the statute. The representative mentioned my case specifically during a committee hearing, noting that it highlighted the need for stronger protections against HOA overreach. Meanwhile, the Sunset Ridge community slowly recovered from the drama. A new HOA president was elected, a mild-mannered retired accountant named Thomas, who immediately reached out to me to apologize on behalf of the board. "We're trying to move forward in a more collaborative way," he told me over coffee one morning. The previous administration was too focused on enforcement and not enough on building community. We want to change that. True to his word, Thomas and the new board took a different approach. They revised the HOA's enforcement procedures to include a mandatory mediation step before any fines could be assessed. They also clarified the rules about landscaping to explicitly permit food gardens as long as they were maintained in good condition. And they started hosting community events like neighborhood barbecues and holiday parties, which Brenda had never bothered with. As for Brenda Morrison herself, I did not see her again after the trial. Her house sold in December, and she moved away. I heard through the neighborhood gossip chain that she had relocated to Sun City, a retirement community north of Phoenix. I hoped that maybe she would find a place where her desire for order and control would be better suited, though I suspected she would probably end up in conflict with whatever HOA board existed there. Christmas came, and I spent it at my house with my sister and her family visiting from Colorado. My nephew, who was 8 years old, was fascinated by the garden and asked a million questions about how plants grew. I let him help me harvest some winter lettuce and carrots, and his face lit up when he pulled a huge carrot out of the soil. Watching his excitement reminded me why the garden mattered so much. It was not just about vegetables or standing up to the HOA. It was about connecting with the earth, about creating something with your own hands, about the simple joy of watching seeds turn into food. In February, I received an invitation to speak at a community gardening conference in Phoenix. The organizers had read about my case and wanted me to talk about the legal aspects of urban food production and homeowner rights. I was nervous about public speaking, but I agreed to do it. The conference was attended by over 200 people, including urban farmers, community garden organizers, and HOA residents who wanted to start gardens. My presentation was well received, and afterward, dozens of people came up to shake my hand and share their own stories. One woman in particular stuck with me. Her name was Amanda Davis, and she was a single mother of 3 living in Mesa. She told me that she had wanted to start a vegetable garden to help feed her family and save money on groceries, but her HOA had threatened her with fines. After reading about my case, she had cited the state statute in a letter to her HOA, and they had backed down immediately. "You saved me so much stress and probably thousands of dollars," she said, tears in her eyes. "I can't thank you enough. Moments like that made everything worthwhile." The stress, the legal fees, the months of anxiety, all of it had led to something meaningful. I had not only protected my own garden but had helped establish a precedent that would protect other homeowners as well. Spring arrived, and my garden exploded with new growth. I planted tomatoes again, along with peppers, squash, cucumbers, and herbs. I also added some flowers to attract pollinators, and my front yard became a haven for bees and butterflies. Neighbors would stop by regularly to admire the garden and ask for advice on starting their own. 3 other families on my street ended up planting vegetable gardens that spring, inspired by my success. The new HOA board even featured my garden in the community newsletter, with a short article about the benefits of urban food production and tips for getting started. It was a complete turnaround from the hostile treatment I had received a year earlier. The article included quotes from me about choosing the right plants for Arizona's climate and the importance of soil preparation. Thomas, the new HOA president, wrote a brief introduction noting that the board wanted to encourage sustainable practices and support residents in their gardening efforts. In April, I received my final communication related to the lawsuit. It was a letter from David Frost, the attorney who had represented the HOA. In it, he expressed his personal regret about how the case had unfolded. He explained that he had advised Brenda Morrison multiple times that the HOA's position was legally weak and that she should consider settlement or mediation, but she had refused to listen. He wrote, "As an attorney, I have an obligation to advocate for my clients, but that doesn't mean I agreed with the approach that was taken. Your garden is beautiful, and the HOA's treatment of you was inappropriate. I hope you'll accept my personal apology for any distress the litigation caused, even though I was ethically required to defend my client's position. I appreciated the letter. It was a reminder that even in contentious situations, there are usually reasonable people on all sides who are just trying to do their jobs. I wrote back to thank him for the apology and to let him know there were no hard feelings. As summer arrived and the weather grew hot again, my garden required more attention. I installed shade cloth over some of the more delicate plants and made sure everything was watered properly. The tomatoes from last year had reseeded themselves, and I had volunteers coming up all over the garden. I let some of them grow in unexpected places, enjoying their wild enthusiasm. One evening in June, I was out watering when a car pulled up in front of my house. A woman about my age got out, followed by 2 young kids. She walked up to my fence with a hesitant smile. "Are you Lucas Patterson?" she asked. "That's me," I said, setting down the hose. "I'm sorry to bother you, but I had to stop. I've been following your story since I read about it in the newspaper. I live in Chandler, and I've been wanting to start a garden, but I was worried about my HOA. Your case gave me the courage to go ahead with it. I planted my first garden this spring, and it's been amazing. My kids are learning where food comes from, and we're eating fresh vegetables every day. I just wanted to thank you in person." Her kids, a boy and a girl maybe 6 and 8 years old, were peering through the fence at my garden with wide eyes. "Can we see?" the girl asked. I opened the gate and let them in. For the next 20 minutes, I gave them a tour of the garden, showing them the different plants and letting them taste a cherry tomato fresh off the vine. The kids were delighted, and their mother was nearly in tears. "This is exactly what I want for my family," she said. "You've inspired so many people." After they left, I stood in my garden as the sun set, painting the sky in shades of orange and pink. I thought about how strange the past year had been, how a simple decision to plant some vegetables had turned into a legal battle, and then into something much larger. I thought about Brenda Morrison and wondered if she ever reflected on what had happened, if she ever considered that maybe she had been wrong. I doubted it. Some people are so invested in being right that they can never admit their mistakes. But I also thought about all the positive things that had come from the experience. The strengthened state law that would protect other homeowners. The dozens of people who had reached out to say my case had helped them. The new garden at Amanda Davis's house that was feeding her children. The 3 families on my street who were now growing their own food. Even the changes in my own HOA, which was now more collaborative and community-focused. My garden had become more than just a collection of plants. It had become a symbol of the right to use your own property as you see fit, within reasonable bounds. It represented standing up against petty tyrants who abuse small amounts of authority. It showed that ordinary people could fight back against institutions and win if they had the law on their side and the courage to persist. As the years passed, my garden continued to thrive. I experimented with different varieties of vegetables, added fruit trees to the backyard, and even started keeping bees. The garden evolved and changed with the seasons, always offering something new to learn and discover. It remained a source of joy, relaxation, and accomplishment. The legal precedent from my case was cited in several other HOA disputes across Arizona, helping homeowners protect their gardens and push back against overreaching associations. Richard Chen, my attorney, told me that my case had become a go-to reference for anyone dealing with HOA conflicts over food gardens. It even made it into a legal textbook, used at Arizona State University's law school. I occasionally thought about Brenda Morrison and wondered what had become of her. Did she ever realize that her rigid adherence to rules and her need to control others had ultimately cost her position, her reputation, and her home? Or did she still believe she had been right and that the world was simply unfair? I would never know, and ultimately, it did not matter. Her actions had consequences, both for herself and for the positive changes that came afterward. Looking back on the whole experience now, I realized that the garden had saved me in more ways than one. It gave me purpose during a difficult time in my life. It connected me with my neighbors and community. It taught me about perseverance and standing up for what I believed was right. And it showed me that even when facing seemingly powerful opponents, individuals could make a difference if they refused to back down. The tomatoes continued to grow red and ripe in the summer sun. The peppers flourished in the heat. The herbs scented the air with basil and rosemary. And every morning, I walked out into my front yard, looked at the garden I had fought so hard to protect, and felt grateful that I had refused to let anyone take it away from me. The judge's laughter in that courtroom when Brenda had tried to justify her excessive fines had been a turning point, a moment when authority recognized absurdity for what it was and ruled accordingly. My garden was not just mine anymore. It belonged to everyone who saw it and felt inspired to create their own. It belonged to the children who learned that tomatoes did not come from grocery stores, but from plants they could grow themselves. It belonged to the lawmakers who strengthened protections for urban agriculture. And it belonged to every homeowner who looked at their own HOA's unreasonable demands and decided that maybe, just maybe, they could fight back too. The sun set over my garden in Scottsdale, Arizona, casting long shadows across the raised beds and making the vegetables glow in the golden light. I picked a ripe tomato, still warm from the day's heat, and bit into it. The flavor was incredible, sweet and tangy and fresh in a way that store-bought tomatoes never were. This was what I had been fighting for, this simple pleasure of growing my own food on my own land, and I had won.